Let's roll, nerds. So we have on 412, possession of marijuana. We have possession of a controlled substance. 721, you pick up an unlawful carrying of a weapon while intoxicated, and another felony possession of marijuana. I'm sorry, 721, you pick up a felony possession of marijuana, DWI with a child, and now you've picked up the next day an unlawful carrying of a weapon.
Oh, no, sir, that happened all together, sir.
We're going to do probable cause. You have the right to remain silent.
Yes, sir. Yes, sir.
Anything you say can and will be used against you.
Yes, sir.
All I know is that you are now on your
This isn't just another bond hearing. This is a judge confronting a defendant who is now on his 6th case. We're talking drugs, a DWI, and now a weapon charge, all while allegedly violating a direct court order not to drive. That affidavit the judge mentions, that's serious. When you promise a court you won't drive and then get caught driving intoxicated with a child in the car, you're not just facing new charges, you're risking contempt of court. And when a judge starts talking about contempt this early, it means patience is gone. The real question is this reckless behavior or total disregard for the court's authority?
Now on your 6th case. Please.
On July 21st, 2024, officers conducted a traffic stop on a vehicle for continuously failing to maintain a single lane of traffic and almost striking multiple vehicles in traffic cones and driving in 2 lanes at a time. The defendant was ID'd as the driver, and officers observed a small amount of marijuana on his lap. Officers also observed bloodshot eyes, slurred speech, and the defendant admitted to consuming 2 to 3 shots and smoking marijuana prior to driving. An adult female was in the passenger front seat and a 4-year-old.
And you have an affidavit that I ordered you not to drive.
And a 4-year-old child was in the car seat in the back seat. The scene was moved to a well-lit gas station, and the defendant was observed to have an odor of marijuana coming from his person, an odor of
Smoking dope in the car with a 4-year-old child?
No, sir.
I'm sorry, a 4-month-old?
No, sir.
4-year-old, but there was marijuana on his lap, and then officers smelled marijuana.
No, sir, I was not smoking in the car, sir.
Don't say anything.
Sir.
Mr. Walker,
Sir.
I am now going to serve you with a hearing as to why I shouldn't hold you in contempt of court. You promised me you wouldn't drive. You signed an affidavit with me that you wouldn't drive. And now you've picked up a DWI with a child passenger. You are now looking at 180 days in jail. I am now revoking your bonds, and I'm setting them all at $15,000. And I'm going to serve you with a new lawsuit as to whether I shouldn't hold you in contempt.
Yes, sir.
Do you understand?
Yes, sir.
Right here is where things escalate fast. The judge isn't reacting emotionally. She's responding to a clear bond violation. When someone is released pre-trial, it's based on trust. Break that trust, especially with a DWI involving a 4-year-old, and the court can revoke bond immediately. Now, add in the inventory search. Over 130 grams of marijuana, mushrooms, THC liquid, Xanax, and a gun. That's no longer a simple traffic stop. That's a serious public safety issue. And when the judge starts mentioning CPS involvement, that signals the court sees potential child endangerment. Let me ask you, if you were on that bench, would you have revoked bond instantly?
Unbelievable how he would get another general order bond. You said there was the odor of marijuana in the car, and how old was the child?
4, but an inventory search also recovered 130.8 grams of marijuana and 18.2 grams of mushrooms, 64.4 grams of THC liquid, 42.9 grams of liquid in vape pens, and then 1.2 grams of Xanax and a gun. So,
I find that you are a complete and utter danger to society, Mr. Walker. You refuse to comply with bond conditions. And I don't know if now CPS should get involved with your case. But I'm also now going to reach out to my staff lawyers to see if that's something that I should also have looked into, whether that baby is protected or whether CPS shouldn't get involved, because you have a complete whole host of 4 to 5 illegal drugs with a 4-year-old in the car. Does it say anything where the 4-year-old was
In the-
buckled up,
in the
running
car
loose?
seat, in the back seat. So the baby was in the car seat.
Unbelievable. So on the possession of marijuana, on the possession of a controlled substance, on the new gun case, all at 15,000, please. Yeah,
And Your Honor,
or I don't know, maybe I'm gonna do higher. I don't know. I'm gonna go.
I was just gonna say procedurally, it looks like we charged him first for UCW law in talks under clause 2520890. That was no PC, so the actual case that we have in our court, the new law violation, is the one we're doing PC on is 2521021.
Correct.
Yeah.
That's what we're doing PC on the new gun case that he just caught.
Correct. So I filed a dismissal on that UCW law in talks. It's just a refile of that case.
I see.
Yeah.
Who dismissed that one? The magistrate?
I filed a dismissal. just-
I mean,
Oh, who got no PC was the magistrate.
that's what I was wondering. Okay.
Yeah.
I don't know. I think probably 15,000 is just. Yeah, I mean, I'm going to set it at 30,000 on all of your cases, Mr. Walker.
Sure.
Like I said, I think that you're an utter, complete danger to society. You refuse to comply with bond conditions. You promised me you wouldn't drive, and here you are. You picked up a DWI with a child.
Driving first, sir.
I'm not going to talk about the case. I will appoint you a lawyer today, but so I need you to do conditions that if he is released, he is not to have any contact with the 4-year-old child. He is not to drive. GPS monitor prior to release. Home confinement. Only to go to a doctor or to meet with a lawyer. No weapons. No drugs, no alcohol. He will be if he does bond out, he will be required to appear every Monday and Thursday to take a drug test. Anything else? Family? Anything else?
Judge, we'll defer to the court.
I think that's it, right? What we do? And then no driving. Yeah. He goes with you.
For both of his UCW
So
and his
the,
possession of controlled substance and possession of marijuana, 30,000, all four.
all of them, yeah.
Just checking.
Well, no, there's only 3, right?
There's 3, and then there's one that was no PC.
Right. So that one, they filed a dismissal on.
Oh, okay.
So they're going to dismiss that one
Gotcha.
because it's got refiled as this new one here. Unreal. Unbelievable. Unreal.
Let's break down what just happened. The judge doubled down. Bond set at $30,000 across the cases, GPS monitoring, home confinement, no driving, no drugs, no alcohol, twice weekly drug testing, and even no contact with the child if released. That's a sweeping set of restrictions. Why? Because bond isn't a right, it's conditional freedom. And from the court's perspective, those conditions were ignored. The larger takeaway here is simple. When you violate a judge's direct order, especially in a case involving substances and a minor, the response will be severe. So, what do you think? Was this judge protecting the public or going too far? If you found this breakdown insightful, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more intense courtroom analysis.